Our parents applying for maintenance claims from their children will now have to first declare if they have a record of abusing, neglecting or abandoning their children.
That's all part of amendments to a law on parental support that seeks to prevent its misuse and keep neglected or abused children from having to financially support their parents. Tan Se-hui reports.
Key among the 4 amendments is a requirement for parents with records of abandonment, abuse or neglect against their children to seek permission from a tribunal before proceeding with their claim. Under the new claim application process, parents must first declare whether they had records of abuse, neglect or abandonment. The Commissioner will check databases for records including personal protection orders. Tribunal may grant permission if the parent can make a compelling argument. The goal is to prevent affected children from being re-traumatised.
We want to put in place processes to prevent those who had abandoned, abused or neglected their children from misusing the MPA and to spare their children from unnecessary distress. For abuse victims, the mere experience of going through the proceedings under the MPA can be distressing because it involves facing the parent after years of avoidance and recounting the experience that they had tried to forget.
Currently, around 1 in 3 cases at the tribunal for the maintenance of parents involve people who allege their parents abandoned, abused or neglected them in their childhood. Other amendments give more latitude to the tribunal to dismiss applications deemed frivolous. The work group set out the amendments to balance misuse and the need for able children to support their destitute elderly parents. This means the Commissioner can also bring children in for conciliation with or without their parents' consent to convey the legal obligation to support their parents. MPs had their concerns.
It is not an easy thing for the government to have to balance. Do we respect the elderly parents' wishes who do not want to approach their children? Or do we go ahead and claim in consideration of fairness in the allocation of resources?
The work group has emphasized that the amendment is intended for the Commissioner to intervene only as a last resort, after the welfare home has exhausted all other options and only if the Commissioner reasonably believes that the parent has no records of abandonment, abuse, or neglect, and that the children can afford the maintenance.
Other concerns include children's fears that maintenance might go to parents who have issues such as gambling and alcoholism. So a final amendment is made to ensure maintenance can be made in non-monetary terms.